Chapter 4 of Tractate Shevuos deals with further laws of oaths, particularly on oaths of testimony. The first Mishnah says, the laws of oaths of testimony apply to men, but not to women, whose testimony wasn't typically accepted. It applies only towards non-relatives, as a person cannot testify towards their relatives, and it only applies towards people that are eligible to testify. Rabbi Meir says, if somebody makes a false oath of testimony, he's liable whether it was done inside or outside of court. This applies if the oath was spoken by the man, and as for if somebody else speaks the oath, and this man is just verbally confirming its veracity, there's only liability if done in court. The sages say there's only liability for typical oaths or confirmation oaths if they're performed in court. Witnesses are liable for testifying falsely, whether they do or do not know the punishment for doing so. They are not liable if they thought they were testifying truthfully at the time. The punishment for intentionally giving a false oath in court was a variable chatas offering. The Gemara brings scriptural sources for the point that female witnesses are typically disqualified, here being the verse, the two men shall stand before the court. It further clarifies this as to how it specifically applies to witnesses testifying in court, and argues as to whether this verse actually obligates those giving testimony to stand while doing so. From other verses, it teaches that you must always judge your fellow favorably. It further argues as to whether litigants are required to stand while giving testimony. Related incidents on this are cited. Related, it said that if a rabbinical student and an unlearned person are in a lawsuit, the rabbinical student sits, and therefore we also tell the unlearned person to sit, and he can choose to do so if he wants. Incidents are cited on this. Also, in such a situation with a rabbinical student and an unlearned person, the rabbinical student shouldn't arrive early to sit before the judge, as otherwise it would look like he's presenting his case early, which isn't allowed. This would be allowed if it's just time for his daily studies and he's doing so. It's also said that a rabbinical student can choose to not use a court that's less prestigious than himself. This principle applies only to financial law, as by matters prohibited by God, there's no concerns of personal respect. Some say that the dispute as to if you must stand applies only to litigants, while all witnesses must stand. Additionally, the verse, distance yourself from falsehood, teaches a number of different things. That a judge shouldn't defend his incorrect opinion, an ignorant student shouldn't sit before a judge or witness shouldn't judge or testify alongside a colleague, and a judge shouldn't testify according to a testimony he knows is false and just let the responsibility hang upon the false witnesses. Additionally, it teaches that a student sitting before his teacher who sees room to absolve somebody must say so. A student who sees his teacher making an error in judgment should say so immediately and not wait until the end to claim credit. A student shouldn't testify on behalf of a teacher simply because he knows him to generally be very honest. A person shouldn't claim to be owed more money than he's actually owed to try and get the man to just admit he owes the original sum. If somebody owes somebody money and the lender claims more than what he borrowed, the borrower shouldn't deny the claim entirely in court and then admit it outside to prevent himself from needing to take any oaths. If 3 men are owed money from 1 man, one of them shouldn't act as a litigant, with the other 2 being witnesses. If a rich man and a poor man are in court against each other, they should dress similarly to prevent any biases, and a judge shouldn't hear one litigant's argument or have a case clarified without the other litigant being present. It brings other sources for these principles. When we said that the only people who are liable for a false oath of testimony are those fit for testimony, some say this is to exclude kings. Others say this is to exclude gamblers or a king. Regarding the debate as to whether there is liability for false oaths of testimony fully verbally given outside of court, it explains this is argued from how it's derived. This is discussed further. It also sources the point that witnesses are liable for fully knowing violation of the laws of oaths of testimony and for a false testimony where they don't know the punishment. We also said if a witness completely accidentally gives a false oath of testimony, there's no liability. This cannot be learned as a proof towards the debate which exists by an accidental ordinary false oath, as based on verses they're just not comparable. New Mishnah. The actual case of an oath of testimony is essentially where a litigant requests of witnesses to testify on his behalf, and they say that they're unable to do so and take oaths that they have no knowledge of the case. This can be done verbally by taking an oath that they have no knowledge of the case, or via confirmation by the other person asking them if they're willing to take an oath and them just saying yes. There's liability to bring an offering if this is a false oath. If the witnesses were requested 5 times outside of court to come and they denied each time, if they eventually do come, they're not liable. If they denied each time within court, they're liable for each time for each of these. If they were requested 5 times in court and then denied all at once at the end, they're only liable once, as they can't retract this. If 2 witnesses denied knowledge of testimony at the same time, both are liable. If they denied one after the other, only the first one is liable. If one denied knowing testimony and the other one admitted to knowing testimony, the one who denied it is liable. If there were 2 groups of witnesses and they both deny testimony one after the other, both are liable, as either could have established testimony by themselves. The Gemara says there's an opinion that witnesses are only liable for false oaths denying testimony if they hear from the litigant himself that they should testify and then deny him. This shows that if the litigant is chasing after them and they take false oaths to not testify, they're not liable. they're only liable if they're actually asked to testify. It also stresses the point that witnesses are only liable for falsely taking an oath that they can't testify if that's done within court as opposed to outside of it. When we said that if both witnesses deny giving testimony simultaneously, that both are liable, this is either in accordance with the opinion that it's just possible for two things to be done precisely simultaneously, or it's just that they said it within the time it takes to make an utterance, which it defines. We said that if one man testifies after the other, the second is not liable. Others dispute this, essentially arguing over if a testimony that can lead to a monetary payment, if that's considered as if it directly leads to such a payment, which is described further. It argues on some additional cases, particularly a famous case wherein a man grabbed the silver ingot out of the hands of another man, and the other brought a single witness that this had occurred, but the man who had grabbed the ingot admitted he had done so, but only as he was the actual owner of the ingot. It's essentially stated that there's insufficiency on basically every level, as there aren't two witnesses, but there is a single witness, so there's no credibility to the fact that the man admitted his guilt. And as he admitted his guilt, he's legally a thief now, so he can't take an oath. So it's simply ruled if somebody would be obligated to take an oath and is unable to do so, he must pay, so here he would be obligated to return the ingot. It discusses other cases of oaths by singular witnesses. If a single witness denies giving testimony on a woman's husband's death, there's no liability if he privately admitted the fact to the widow, but if he refused to tell her and the court, there'd be liability. Then we had said that if one witness denies testimony and the other admits, the denier is liable. This is necessary to state to show this applies even if both deny testimony and then one retracts his denial within a brief period. When we mention two groups testifying, it clarifies that both are liable, as at the time of the first group's denial, the second group were related to each other through their wives, so they couldn't temporarily testify. This would even apply if their wives were about to pass away, as they haven't died yet, so this all still applies. New Mishnah. If a litigant requests of a witness to testify that somebody has his deposit, his loan, a stolen object, and a lost object, and the witness takes a false oath that they know of no testimony for him, they have one liability. If they take a false oath that they don't know of the deposit, loan, stolen object, and lost object, they're liable for each listed item. Similarly, if somebody asks witnesses to testify that he has in his possession somebody's wheat, barley, and spelt, and the witnesses take a false oath that they don't know of any testimony for him, they have one liability. If they take a false oath that they don't know of his wheat, barley, and spelt, they're liable for each of those. Specifically, if somebody asks of witnesses to testify that he has payment of damages or half damages for somebody, or a double payment, or 4 or 5 times payments, or that somebody violated or seduced his daughter, or that his son had struck him, or that somebody had wounded him, or that somebody had burnt his grain on Yom Kippur, where it'll explain there's a financial payment. In all these cases, if the witnesses falsely take oaths to deny testimony, they're liable. The Gemara asks, is there liability for falsely taking an oath to deny testimony on an imposed financial penalty, in accordance with the opinion that if somebody admits guilt, they're exempt from paying a penalty, and specifically according to the opinion that something that can lead to a payment of money is not considered as if it directly causes a monetary payment. It argues this from several listed cases, including our own Mishnah. It essentially proves that a penalty is the same as typical monetary obligations, meaning the witnesses who take false oaths to not testify here would be liable. New Mishnah. If somebody requests of witnesses to testify that he's a Kohen, or a Levi, or not the son of a divorced woman, or a woman who had done chalitza, or that somebody else is any of these, or that somebody else violated or seduced somebody else's daughter, or that his son wounded him, or that on Shabbos somebody else wounded him, or lit his grain on fire, in all these cases, as there's no monetary penalty, as there's typically more severe punishments, there's no liability for a witness who falsely takes an oath to deny testimony. The Gemara discusses and sources these points that liability for false oaths of testimony only apply to monetary cases. There are a number of these. These are additionally discussed. It also brings some particular cases of incomplete testimony and further explains the sources. New Mishnah. Some additional cases where there's no liability for false oaths of testimony. If somebody asks witnesses to testify that somebody promised him 100 coins and they hadn't delivered it, there's no liability if they falsely deny him an oath, as there's no actual monetary claim, such as a deposit. Or if somebody asked men that if they eventually become witnesses, they should testify, they're not liable for this false oath, as the oath came before their knowledge of testimony. Or if the person asked a room full of people to testify for him, if one of them, the witness, takes a false oath to deny this, there's no liability as he wasn't directly addressed. Also, if a person directly asked witnesses to testify for him and they falsely deny this via an oath, but their knowledge was secondhand, or one was relative or otherwise ineligible, there's no liability. Lastly, if the person sent a slave on his behalf, or the defendant asked the witnesses to come and testify, the witnesses have no liability if they deny knowledge of testimony with an oath. The Gemara brings scriptural sources for these points. Also, regarding the litigant asking the room full of people that the witness is allowed to deny testimony as he wasn't directly asked, this would apply even if he was directly next to the litigant when he asked this question. It sources the remaining points. New Mishnah. If somebody requested of a witness to testify for him using the words to adjure, or he commanded him to do so, or bound him to do so, then the witness is liable for taking a false oath of testimony. If they swore by heaven and earth, they're not liable. They are liable if they swore by the name of God, which it gives a list of all the names or terminologies which are considered to be names of God. Also, Rabbi Meir says there's capital punishment for blaspheming or cursing one's parents by any of these names. The sages say only by one specific name. Cursing another person or oneself by any of these names is prohibited. It also works to tell the witness, may God strike you if you don't testify for me, so that if he takes a false oath, he's liable, as that's an expression used in the Torah. If somebody said, may he not strike you if you testify for me, or may he bless you, or benefit you, Rabbi Meir says the witnesses are then liable for false oaths. The sages disagree. The Gemara clarifies the particular expressions of requesting somebody's testimony being I adjure you with an oath, or I command you with an oath, or similar. It also further clarifies exactly as to what constitutes the various names of God. It discusses these further and also prohibitions of erasing God's name, and a few scriptural occurrences like Lot and his escape from Sodom, and the prophet Micha and others, and the names of God used in scripture around their stories as to exactly which ones are considered divine or otherwise. There are further verses discussed and additional points on false oaths of testimony. It brings many specific terminologies, which it defines as referring to an oath. Words like aror, amen can be used to accept an oath. There are a number of others. It sources the debate as to which names of God are considered blasphemy to use improperly. As mentioned, everybody agrees that cursing another or oneself by any of the names of God, which it also sources, is forbidden. It quotes incidents in the remaining points. These are discussed, and that's the end of chapter 4.